Hello and good morning. I hope that you can hear me. It's Stephen Tromans, and welcome to, or welcome back to, if you've listened before, to our series 3 of 39 from 39 events. We're running a short series looking at the UK and EU Trade and Cooperation Agreement, and in particular today, a general topic on environment and energy. Next slide, please. So I'm going to give a short introduction, and then I'll introduce my co-speakers, Ruth and Gethin. So our Prime Minister achieved, so he would tell us, the 11th hour deal on Christmas Eve. The Trade and Cooperation Agreement is provisionally in force from the 1st of January this year. I say it's provisionally in force because it's still to be ratified by the European Parliament and European Council, which we understand will be around April. You need to read it together with our old friends, the Withdrawal Agreement and the Northern Ireland Protocol, which we all know about. We've talked about those before, and also a new friend, the European Union Future Relationships Act of 2021, which I'm going to call EUFRA. So next slide. The background to this, the former World Trade Association head, Pascal Lamy, categorized this as the first negotiation in history where both parties started off with free trade and then discussed what barriers to erect. And that, of course, is the fact. The agreement is tariff-free trade, but as I'll explain, it's certainly not frictionless trade. The government's approach was, of course, largely cakeism in Boris's terminology, wanting to have your cake and eat it, that is to say, retaining as much access as possible to the single market, whilst accepting as little as possible by way of European law constraints. And the model for this was the Canada deal. As I'll come on to, I don't think it's actually analogous in some respects on the environment to the Canada deal. The EU approach, by comparison, was that there would be no market access while the UK could undercut the EU's economic model on environment, climate change, labour rights, and many other matters of European law. What the EU says about this, in fact, if you want to know about this agreement, the best place to look is not on the UK government's website, it's actually on the European Community website, European Union website, which has very, very thorough notes, slides, commentary on all of this. It's by far the best place to look to understand these arrangements. Anyway, the agreement sets out preferential arrangements in certain areas, but not others. For instance, professional services, as we know, and financial services, largely not covered. There are far more references, I think about 4 times as many references to fish in the agreement as there are to financial services, despite the relative insignificance of fish compared to financial services in the UK economy. The agreement is underpinned by provisions to ensure a level playing field. We're going to be coming back to talk about that. And whilst the EU says it will by no means match the level of economic integration that existed while the UK was an EU member state, well, you can certainly say that again, the agreement goes beyond, it says, traditional free trade agreements and provides a solid basis for preserving long-standing friendship and cooperation. Well, we certainly hope it will do that. We'll look at enforcement provisions and how much sort of mutual trust there is when we look at those provisions. Next slide, please. So the outcome, it's obviously a monster of a document. I don't suppose any of you have read it word for word. I certainly haven't, but I have identified what I think are some relevant bits of it. And we have part 1 dealing with common and institutional provisions, part 2 dealing with trade, transport and fisheries, and I've listed there some of the key headings for our purposes. So Title 8 on energy is vital, Gethin will be talking about that. Title 11 on level playing field provisions, and for future events we may be looking at some sector specific ones. So for instance there are aviation and fisheries which are dealt with. as separate headings. Part 3 deals with law enforcement and judicial cooperation, for instance, in criminal law areas. Part 4, thematic cooperation, how we're going to cooperate on matters such as cybersecurity and health security. Part 5 deals with terms for participation in EU programmes going forward. And Part 6 we'll talk about at the end, dispute settlement and horizontal provisions. Next slide, please. So today's content, I'm going to hand over in a moment to Ruth, who's going to start talking about the level playing field. I'm going to come in at the end of that a little bit. Gethin is going to talk about energy, and then I'm going to give an outline on enforcement. Clearly, we can only scratch the surface this morning, and we are planning some further, more specific sector-orientated events on the 15th of March and the 15th of April. You may wish to put those in your diaries. What I'm going to suggest is that if you would like to make any suggestions to us as to particular sectors that you would like to be covered, obviously there are numerous sectors, renewables, nuclear, energy, generally, chemicals, please email marketing@39Essex with your suggestions, and we will do our best to accommodate your suggestions in designing those future events in March and April. And as we go, please, I'm afraid we can't have live interaction, as it were, by way of you coming up on the screen, but please do use the Q&A function as we're speaking to ask any questions. We've had a few already, which we will try and deal with, and we will try and deal with any which come in as we're speaking as best we can. So I think if we move on to the next slide, that is Ruth. So I'm going to hand over to my colleague Ruth to look at Title 11 and level playing field provisions.
That's great. Thanks, Stephen. Hi, everyone. I'll be giving a quick whistle-stop tour of where we are in terms of Title 11 and the level playing field. As many of you will be aware from following the saga of Brexit, as we all have, these have been some of the most hard-fought provisions in terms of the agreement, and I think we certainly see that reflected in terms of the balance of the final provisions that we have. Looking at those in terms of a breakdown of the most relevant provisions, it's first the general provisions under Chapter 1, which I'll be outlining, also be looking at subsidy control under Chapter 3, and there are certainly some relevant provisions in terms of environmental practitioners under Chapter 3. In terms of the meat of Title 11, we really see that in Chapter 7, and so I'll be spending some time on that. And finally, in terms of Chapter 8, although in broad terms, we do see under Title 11 the reaffirmation of certain international commitments on the UK and the EU, and so that's also relevant to look at briefly. So if we look first at Chapter 1 in terms of the general provisions, I think the importance of this is really if we look at the tone that this sets in terms of the agreement between the UK and the EU going forward. So first, looking at the balance we see in terms of the language there under Article 1.1, that details the principles and objectives that we see carrying throughout Title 11. If we then move on to Article 1.1.3 there, we can see in rather broad terms the reaffirmation of an economy-wide climate neutrality by 2050. And so we do see it there in black and white, but of course, as we'll go on to consider in terms of enforcement of that provision, there are some question marks in terms of the future of Article 1.1.3. And finally, I'd like to highlight in terms of what you see on your screen there, Article 1.1.4. And I think this is really the importance of Chapter 1. It's important to keep in mind that with the exception of certain aspects of it, so many of the precautionary principle and also climate neutrality, this is not a chapter which is going to be enforceable by the agreement's dispute resolution aspects or its enforcement mechanisms. And so really when we're looking at Chapter 1, that subsection 4 is the importance of this section because it sets the tone for the other provisions we see later on. And what it says is that the purpose of this is to prevent distortions of trade and investment. And I think that's really what we go on to see later, particularly in Chapter 7 in terms of the language. And finally, what it says there is that the parties recognise that the purpose of this title is not to harmonise the standards of the parties. And that's certainly something which we see reflected in both the language and the substance as we move through Title 11. Looking then at the next chapter in front of you, we see Chapter 3, and that's subsidy control. And it is worth briefly highlighting to those on the webinar that there are certain carve-outs to subsidy control which are in Title 11, and you see them there in terms of Article 3.5. The first I would flag for you is a slightly progressive attitude that's been taken in the agreement in respect of energy and the environment. And what's said there is that the parties recognise the importance of secure, affordable and sustainable energy. That is something that's important. There's a certain carve out here in terms of subsidy controls. And on the other end of the spectrum, I think we also see some limiting of harmful practices there under 15, where it says subsidies to air carriers for the operation of routes. And that very much limits subsidies in those circumstances. And so again, it's important to keep in mind when we read Title 11, principally the importance comes in Chapter 7 in terms of the substance, which we'll come to. But it's also important to read the title of the whole, because we do see certain elements throughout Title 11 which are excluded from Chapter 7, but which are hugely important nonetheless. Importantly, now we move to the meat of Title 11 in terms of the environment and climate, and you'll see there in front of you Chapter 7. In particular, I'll be outlining Articles 7.1 to 7.4. We can't, unfortunately, in the time given, go through the detail of all of these provisions, although Stephen will be touching on Articles 7.5 to 7.7 in terms of how enforcement and dispute settlement is going to work in terms of these articles. But it's important to first look at the definitions. And if we look at the scope of protection, which is given by Title 11, we'll see the scope there under Article 7.1.1. And indeed, I don't think there's anything surprising there. It's certainly broad in terms of its scope, but I think nonetheless it includes the areas which we would all hope to have included. But I would flag to everyone on the webinar that importantly at Article 7.1.2, it does clarify that for the EU, only environmental levels of protection that are common to all member states are in scope. I don't think there's anything surprising in terms of what we see there in the language, but it is important to note that, of course, this is a trade agreement, and so it is very much about the mutual relationship, both presently and moving forwards, between the UK and the EU. Now, in front of us here, in my view, is the most important aspect, I think, probably of Title 11, although Stephen, of course, feel free to disagree with me, and certainly in terms of Chapter 7. And there's a certain number of points I'd like to note there. The first is that this is really the most substantial aspect or interpretation we get of how this section is going to work in practice. What we don't have time to fully go through in terms of this is the scope of issues which might arise. But I think looking at the language there's a couple of important points to note. The first is that if we look at Article 7.2.1, it's affirmed that the UK has the right to determine its own levels of environmental protection, and that's affirmed, so long as that is consistent with international commitments. Again, I don't think there's anything surprising here, but it's important to highlight the scope here and the liberty which has been given to the UK for the better or the worse, indeed, to modify its environmental standards, so long as they are consistent with international commitments. And really then, and I've highlighted it there, this is the meat of 7.2.2. I'm sure it's something which Stephen is going to pick up and discuss with us. But this is really the ambit that we see in terms of Article 7.2.2. And it's worth focusing on the wording, because what that says is a party shall not weaken or reduce in a manner affecting trade or investment between the parties its environmental levels of protection or its climate level of protection. There's a couple of points to note there. The first is that that is by reference, as we'll see on the language, below the levels that are in place at the end of the transition period. And so I certainly think there's a question mark left by the language of Article 7.2.2 as to how aspirational one has to be in alignment with this agreement. But more importantly, I think in terms of challenges moving forward, of course, we have to keep in mind that this is a trade agreement, and so it's not something which could be brought before the courts. It is very much something which is a beast of public international law. But nonetheless, even given that narrowing in scope, I think we see a further narrowing here at Article 7.2.2, when it said has of course to be, given it's under Title 11, in a manner affecting trade or investment between the parties. And again, here we see something which does represent quite a high hurdle in terms of demonstrating that there has been some weakening of environmental standards. If we move through to the next slide there, we see Article 7.2, again, the final sections of that. The one that I would draw your attention to is that the language of subsection 5 here says the parties shall continue to strive to increase their respective environmental levels of protection or their respective climate level of protection. A feature, I think, when we look at the language, certainly of Title 11, it being, of course, a feature of public international law, but also a trade agreement, is that we very much see the language of business here. And I think as lawyers, that might leave some question mark as to what it really means in terms of Article 7.2.5 to say the parties shall continue to strive to increase their respective environmental levels of protection. It's certainly an aspirational statement, but the extent to which that's going to help people in practice, I think, is rather questionable. If we move through to another important aspect now on our whistle-stop tour, in terms of Article 7.3, this is to do with carbon pricing. And there's a couple of points to make there. The first is that this has to be in place from the 1st of January 2021. It covers electrical generation, heat generation, industry, and aviation. And there is a 2-year derogation for aviation if it's not already covered. What's also important there in terms of the language, and I think, again, this is something which is reflected in the language of Article 7.2, is that the party has to maintain their system of carbon pricing, and then it moves on to say the parties shall cooperate on carbon pricing. So I think it's unsurprising that what we see here in terms of Article 7.3, much like the rest of Title 11, is the aspiration the parties will work together moving forward. But of course, the acknowledgement that the nature of this agreement between the UK and the EU is that the UK may subsequently in the future adopt slightly different standards. And certainly that's present in terms of the language we see in Article 7.3. Finally, again, I think we'll all be familiar, these are old friends in terms of the screen here, in terms of the principles which have survived Brexit and which are affirmed here on our screen. Again, it's important to keep in mind the ones that have been included, and when I've listed them there. Again, something which has to be read in the context of Article 7.2, and certainly in terms of the dispute resolution mechanisms between the parties, but nonetheless, important principles to keep in mind in terms of those which have survived the Brexit deal. And finally, in terms of Title 11, there's a number of aspects of Chapter 8 which are also important in terms of the environment and climate change. Again, thematically, when we look at Title 11, very much the meat of the provisions, which I would envisage would cause some of the difficulties in the future. And certainly if there were to be any disputes between the UK and the EU, are contained in Chapter 7. But when we're looking at any disputes that could arise under Chapter 7, we do have to keep in mind also Articles 8 and under Chapter 8. And there's a number of aspects there which are relevant to the environment. In terms of an overall scheme, in terms of how Chapter 8 operates, there are also some provisions in here to do with labour, but there's also many provisions, as you'll see in front of you, to do with sustainable development, and in particular, the aspiration and certainly the commitment that the UK and the EU will continue to respect its international commitments. So that, for everyone, there's a brief whistle-stop tour of how the provisions of Title 11 work, interact with each other, and certainly how some of, in my view, the most contentious provisions read. And now I'm going to pass over to Stephen to illustrate some of the practical issues which might arise with these and some of the difficulties we might see between the UK and the EU in the future.
Thank you very much, Ruth. That was very clear. So I'm going to pick up on some of the themes which Ruth has begun to highlight. I think the first point to note is that Article Comprov 16 makes it clear that the agreement is neither binding on individuals nor enforceable in domestic courts. So this is not something which individuals or interest groups are going to be able to take along to court and say the UK is not complying. It's a matter of public international law. Those issues generally are not justiciable in the UK courts. And it's clear from the article of the agreement that they won't be. The courts won't hear those cases. That's subject, I think, to one point I'm going to make in a moment. UFRA 2021 gives rise to a number of very important, potentially regulation-making powers, general power to make implementing regulations under Section 31 of UFRA in order to bring into law parts of the agreement as necessary. Also a new power under the Customs and Excise Management Act 1979 for the commissioners to make regulations for monitoring or controlling goods that might pose a risk to public health or safety, national security, or to the environment. So I think we can expect to see quite a lot of regulation-making activity in months to come under these provisions. But it's also very important to note section 29(1) of UFRA. I've set it out there. It reads that existing domestic law has effect on and after the relevant day, with such modifications as are required for the purposes of implementing in that law the agreement or the security of classified information agreement, so far as the agreement concerned is not otherwise so implemented, and so far as the implementation is necessary for the purposes of complying with international obligations of the UK under the agreement. So what that means is that there is, if you like, an automatic modification of domestic law in order to make it compliant with the international obligations of the UK. Now that I think is going to present quite a lot of interesting points of interpretation, not just in environment, but in many areas, as we see how that plays out in cases brought in the courts on the interpretation and effect of existing UK legislation. We'll perhaps come back to that in future webinars. Next slide, please. Barriers to trade. Provided rules of origin are complied with, the agreement secures zero tariffs and quotas. And despite the fact that the Prime Minister said that this would also remove non-tariff barriers to trade, it is far from doing that. It should, to some extent, prevent unnecessary technical barriers to trade by self-declaration in relation to certain low-risk products and certain other products of mutual interest listed there. But the fact remains that all UK goods which enter the EU are still going to have to meet the EU's regulatory standards, including those on food safety and product safety. And so we're already starting to see that, aren't we, in some of the friction which is occurring at the border. It, of course, means that those UK manufacturers who are manufacturing goods that they want to sell in the EU are still going to have effectively to comply with EU law. Next slide. As I said earlier, the government very much touted the CETA, the EU and Canada agreement, as the model for this. I think there's actually no comparison when you read them. CETA is a fully fledged trade and investment treaty. If you look at it, it has very comprehensive provisions on the environment, which you don't find in the TCA. So, for example, Chapter 24, Article 24.5 of CETA contains provisions which make it clear that it's inappropriate to encourage trade or investment by weakening or reducing the levels of protection afforded in their environmental law, and that point 3, a party shall not, through sustained or recurring courses of action or inaction, fail to effectively enforce its environmental law to encourage trade or investment. So that's interesting. When we compare that, as I'm going to do in a moment, with what the agreement says in the level playing field provisions, we'll see it's not quite that level of protection. And also, there is a very important set of provisions in Article 24.6 of CETA on access to remedies and procedural guarantees, which I don't think we find anywhere in the UK and EU Trade and Cooperation Agreement. It's an interesting question as to how far Aarhus and its rights are brought in through the TCA. I'm going to come back to that in just a moment. Next slide, please. Non-regression. So Ruth has already identified correctly Article 7.2, that a party shall not weaken or reduce and these are the key words, in a manner affecting trade or investment between the parties. Those words, I think, are key, because actually demonstrating an effect on trade or investment between the parties may be very far from straightforward. Next slide, please. So to give a few examples on that. The UK at some point in the future hypothetically decides it's going to weaken, for its own reasons, its standards on air quality or water quality. Does that affect trade? Well, not necessarily as such. However, what if the effect of the weakening is to reduce the burden on UK agriculture in producing goods or animals relative to EU farmers? That does, I would think, affect trade. The government has talked about possible changes to the way of setting best available technology for the purposes of industrial sectors under the Industrial Emissions Directive, as it was, of course, that we had to comply with. So there will be, I think, a departure from the Seville approach of common BAT throughout the EU, possibly to different UK standards, either for particular sectors or maybe generally. Now, if that makes it much cheaper for the same goods to be produced in the UK than the EU, does that affect trade? Again, one would think, yes, it may well do. Free ports, you've heard a lot about those. Quite an important part of the government's claimed advantages as a result of leaving the EU. What about if you have reduced regulatory controls on free ports, for instance, on developing in a way that affects habitats, which gives UK port operators an advantage? But then this last one, I think this is where the CETA analogy is quite interesting. What if controls are relaxed over a particular sector in order to attract investment from, say, the US or China? So the Chinese or America want to produce some major new manufacturing facility in the UK, which is of very significant economic importance for a UK region. Environmental standards are relaxed, maybe pursuant to some sort of trade agreement between the UK and the US or China. Does that affect investment between the parties? Now, it affects investment in the UK, but it's not affecting investment between the UK and the EU. So that's going to be quite an interesting debate, I think. All of these examples, and they're not comprehensive, you can see how all of this may play out. Next slide, please. A link to the Environment Bill. The Environment Bill, as we know, as of yesterday, has been pulled from the current parliamentary session. I don't think that was because the government were afraid of Chris Grayling's proposed amendment on hedgehogs. They say it was because of lack of parliamentary time as a result of the COVID pandemic. But what it does mean is that, of course, the much needed provisions of the bill are going to be significantly delayed, and that will include the creation of the Office of Environmental Protection. The Office of Environmental Protection has jurisdiction in respect of environmental law. So complaints can be made of non-compliance with environmental law, which is currently defined by Section 45 as any legislative provision to the extent that it is mainly concerned with environmental protection and is not concerned with an excluded matter. So the TCA is itself not environmental law. Should it be? What would be the implications if it were? But of course, what we have to also bear in mind is going back to Section 29(1) of UFRA, which is environmental law and does require domestic law to be read in such a way as to give effect to the TCA. So perhaps in a rather convoluted way, there is a link back into environmental law through that. So I think we're in quite a complex area here moving forward. What can environmental groups or concerned citizens do if they can't any longer complain to the European Commission and it's not environmental law for the purposes of the OEP? Well, they can, of course, I'm going to come on to enforcement at the end of this webinar, they can, of course, try and instigate, unofficially, if you like, not going through official channels, action by Europe. over breaches of the TCA. So there's no reason why a disaffected company or individual couldn't draw to Europe's attention some alleged failure of compliance by the UK with the TCA. And we'll talk about what the implications of that are in terms of the enforcement provisions and dispute resolution provisions later. But I think for the time being, that takes me through what I want to say. And I think we hand over at that point to Gethin, who is going to deal with energy.
Thanks very much, Stephen. So I'm going to give an overview of the provisions of the Trading Cooperation Agreement that apply to energy. The issues of nuclear energy, renewables, and climate change more specifically will be addressed in a future edition of the 39 from 39 webinars. So first, some context. In a throwback to the blissfully uneventful summer of 2014, the UK government published a review of the balance of competences between the UK and the EU with regard to energy. It provides a really neat account of the history of the EU and energy, observing that very little action was actually taken in respect of energy in the decades that followed the establishment of the European coal and steel community and atomic energy community in the 1950s. During that time, member states' energy mixes and market structures developed independently alongside the decline in the importance of coal and the rise in the importance of oil as energy sources. When the UK joined what was then the European Economic Community in 1973, no specific legal base for energy measures was included in the EEC Treaty. Instead, a general range of provisions based on substantive law, such as the Four Freedoms, provided the legal base for energy measures and legislation. These included its powers to regulate the single market or under general powers to pursue the community's objectives. And this remained the case until express provision was made in the Treaty of Lisbon for the EU's competence in energy, which is on the slide. Article 194 of the Treaty on the Functioning of the European Union prescribes the overarching objectives of the EU's energy policy. Article 194 also made clear that measures made to achieve those objectives were not to affect a member state's right to determine the conditions for exploiting its energy resources, its choice between different energy sources, and the general structure of its energy supply. Please can I have the next slide. In February 2015, the EU Energy Union strategy set out ambitions to realise a fully integrated internal energy market with interconnectors, which is a term describing the physical links, such as electricity cables and gas pipelines that allow the transfer of electricity across borders, providing unconstrained trading of energy across the EU. Currently, the UK has 4 electricity interconnectors with the EU with a combined capacity of 4 gigawatts. A key feature of this strategy was the ambition to develop new infrastructure, especially interconnections, with the aim, among other things, of lowering the cost of integrating renewable energy into the internal energy market. The UK had historically been involved and indeed a driver of this project. Indeed, 2016, the now abolished House of Commons Select Committee on Energy and Climate Change published a report shortly after the Brexit referendum, which observed that the UK energy sector has extensive links with the EU through trade, directives and interconnection. Successive UK governments have championed the liberalisation and decarbonisation agendas within the EU, including the development of the single market in energy. Please can I have the next slide. So the UK and EU energy markets were very deeply interlinked, mainly due to the interconnectors running between Great Britain and France, the Netherlands, Belgium, Ireland, and Northern Ireland. And today, the UK is a net importer of energy, with the EU currently providing some 5 to 10% of its electricity supply and 12% of its gas needs. However, as of New Year's Day this year, the UK left the EU's internal energy market. Please can I have the next slide. On the 14th of December 2020, the government published its highly anticipated energy white paper, Powering Our Net Zero Future, following a series of delays in 2020. I'm not sure in that picture that Mr. Johnson and Mr. Sunak are aware that the cars are behind them. The energy white paper was, perhaps understandably given its timing, relatively light on the UK's future intentions for its relationship with the EU on energy, save for 2 matters in particular. First, it commits to a 3-fold increase on the current levels of interconnector capacity by 2030, an ambitious target, which it says it will require working with its European partners to achieve that. Secondly, it also commits to establishing a UK emissions trading scheme to replace the UK's participation in the EU emissions trading scheme. The UK ETS will be a market-based measure which says continuity for businesses that will set a cap on the number of greenhouse gases that businesses can emit via the total number of allowances in circulation, which is intended to decrease over time. The UK ETS will initially apply to energy-intensive industries, electricity generation, and aviation. Following the introduction of the UK ETS, the government has explained that it will consult in due course on how to align the cap with appropriate net zero trajectory. The EU and the UK have formally committed to giving serious consideration to linking their emissions trading systems, but there is no specific provision for that in the agreement as it exists today. So the energy provisions that do exist are set out at Part 2, Heading 1, Title 8 of the agreement, as well as 4 annexes at page 780 of the agreement onwards. Please can I have the next slide. In summary, these energy provisions concern competition in electricity and gas markets, trading over interconnectors, network development and security of supply, technical operation, safe and sustainable energy, and energy goods and raw materials. The objectives of the energy provisions are said to be to facilitate trade and investment between the parties in the areas of energy and raw materials, and to support security of supply and environmental sustainability, including in contributing to the fight against climate change in those areas. Overall, these provisions, along with many other aspects of the agreement, are prescribed at a relatively high and general level. The energy provisions largely do not seek to attempt to significantly disrupt the pre-Brexit state of energy affairs. The agreement does make alternative trading arrangements which will require stakeholders and regulators to adapt, but there has been an effort made to minimize the disruption. The agreement foresees the possibility to develop over time separate agreements for trade over interconnectors based on the current coupling model that exists in the EU. The EU Commission has explained that the model that is set out in the agreement is different from and less efficient than the market coupling used within the EU. However, the constraints applicable to energy trade between the EU and the UK as now a third country, the model should still allow some benefits to be maximised for both the Union and the UK with regard to the trade of electricity over interconnectors. Notably, the energy provisions will expire on the 30th of June 2026. That's the deadline prescribed under Article 31. Thereafter, further negotiations will be required. This date also happens to be the end of what is referred to in the agreement as the adjustment period set under Protocol on Access to Waters, which permits fishers to continue to access UK waters just as they were able to before the date of the agreement until the 30th of June 2026. So it appears that fisheries and energy will both be back on the negotiating table together at the same time in 2026. Please could I have the next slide? The UK government's summary of the energy provisions is set out in this slide for reference. It flags, among other things, that both parties will develop and implement new further trading arrangements by April 2022 to deal with, in particular, the allocation of interconnector capacity, which is dealt with as more of a stopgap in the current agreement. Article 4 sets out the general principles governing these provisions and makes clear that each party preserves the right to adopt, maintain and enforce measures necessary to pursue legitimate policy objectives such as securing the supply of energy goods and raw materials, protecting society and the environment, including fighting against climate change, public health, and so on. I'm going to highlight a few particular aspects of the energy provisions. Please can I have the next slide? And the next slide again, please. So Chapter 2, Section 1 makes provision in respect of competition in electricity and gas markets. The overarching effect of these articles is to apply a principle of non-discrimination to the electricity and gas market so as to maintain a robust level playing field. Article 5 prescribes a non-discrimination principle, which requires that each party must ensure its regulatory framework for the production, generation, transmission, distribution or supply of electricity or natural gas is non-discriminatory with regard to rules, fees and treatment. Each party is also required to safeguard consumer choice by making sure that customers are free to choose or switch to the electricity or natural gas supplier of their choice within their respective retail markets in accordance with the applicable laws and regulations. Although that article does not apply to cross-border trade and is made explicitly without prejudice to each party's right to regulate in order to achieve what are referred to as legitimate public policy goals based on objective and non-discriminatory criteria. Article 6 is also directed at maintaining fair competition, obliging each party to ensure that wholesale electricity and natural gas prices reflect actual supply and demand, and it also reiterates the importance of ensuring non-discrimination between participants in the markets. Under Article 7, the UK and EU have agreed high-level commitments to prohibit market abuse in energy markets, and in particular, that each party shall prohibit market manipulation and insider trading on wholesale electricity and natural gas markets. Similarly, Article 8 requires that the parties shall ensure the implementation of a system of third-party access to their transmission and distribution networks based on published tariffs that are again applied objectively and in a non-discriminatory manner. These provisions largely mirror the EU's regulation on energy market integrity and transparency, or REMIT, that prohibits insider trading and energy market manipulation and makes provision for the monitoring of the market by regulators. Now, for Northern Ireland specifically, REMIT continues to apply as per the Northern Ireland Protocol to the withdrawal agreement. But in Great Britain, the majority of the existing REMIT regime has been maintained domestically with minimal changes. Existing REMIT prohibitions and obligations are maintained, and Ofgem have the powers to monitor and enforce them. Ofgem published a letter in October confirming the REMIT arrangements that apply in Great Britain from the 1st of January 2021. However, market participants in Great Britain who want to trade in the EU wholesale energy markets, undertaking cross-border trade or trade within the single electricity market, will need to register separately now with an EU regulatory authority. Energy and environmental subsidies. Please can have the next slide. And the next slide again, please, Ruth. Under Annex ENR 2, more generally, the agreement states that, provided that appropriate measures are put in place to prevent overcompensation, non-competitive procedures may be used to grant subsidies for renewable energy and cogeneration if the potential supply is insufficient to ensure a competitive process. The eligible capacity is unlikely to have a material effect on trade or investment between the parties, or subsidies are granted for demonstration projects. So it's fairly delimited. Subsidies for the decarbonisation of emissions linked to industrial activities are required to achieve an overall reduction in greenhouse gas emissions, in particular those emissions directly resulting from the industrial activity. Subsidies for improvements of the energy efficiency of own industrial activities are also required to improve energy efficiency by reducing energy consumption either directly or per unit of production. The chapter also makes provision for trading over interconnectors. Please can I have the next slide. Article 13 imposes a number of high-level obligations on both the UK and EU with the aim of ensuring the efficient use of electricity in connectors and reducing barriers to trade. For example, it requires that there be no network charges on individual transactions on and no reverse prices for the use of electricity in connectors. It also requires capacity allocation and congestion management across electricity and connectors and is coordinated between concerned union transmission system operators as well as UK transmission system operators. Both parties have also committed to taking the necessary steps to ensure the conclusion as soon as possible of a multi-party agreement relating to the compensation for the costs of hosting cross-border flows of electricity. So the devil will be to some extent in the detail of that future agreement. The current cooperation and trade agreement requires that that future agreement must ensure that the UK transmission system operators are treated on an equivalent basis to a transmission system operator in a country participating in the inter-transmission system operator compensation mechanism, and that the treatment of the UK transmission system operators is not more favourable in comparison to that which would apply to an operator participating in that system. These articles are particularly important as in essence they are key to ensuring in future that as frictionless access as possible to the EU and gas electricity market is achieved. Articles 16 to 18, which are on the next slide, make provision requiring both A, cooperation between parties to manage risks to network and security of the supply in future, and B, to ensure that each party individually takes steps to forecast and assess future risks. Articles 19 to 20 also make provision for technical cooperation. Now, with regard to the safe and sustainable energy provisions, by way of background, please can I have the next slide. In June 2018, the Commission, European Parliament and Council reached agreement on a new binding renewable energy target for the EU for 2030 of 32%, including a review clause by 2023 of an upward revision of the EU target. That was adopted in early December 2018 pursuant to the EU Renewable Energy Directive, RED II, which came into force in December 2018 and ultimately repeals its predecessor directive, RED I, from the 1st of July 2021. Under the Trade and Cooperation Agreement, the UK has reaffirmed its ambition for the share of energy from renewable sources in gross final energy consumption and the absolute level of primary and final energy consumption in 2030, as that being set out in its National Energy and Climate Plan, which was published back in January 2019. So in short, what these articles do is make provision for cooperation in the development of offshore energy with a clear focus on the North Sea. The UK and the EU are aiming to be able to continue to cooperate, building on the North Sea Energy Cooperation, a platform which was developed by the EU, a number of its member states and Norway, to continue the use of renewables in the region. The scope of the cooperation in the area of offshore energy envisaged by the agreement reflects the EU's strategy on offshore renewable energy, which was presented on the 19th of November 2020, in which the Commission proposed to increase Europe's offshore wind capacity to at least 60 gigawatts by 2030, and then to 300 gigawatts by 2050. So ambitious targets have been set. With regard to energy goods and raw materials, further articles again are aimed at providing as robust level playing field as possible. And on the next slide, briefly summarize the article. So in the next slide again, thank you. If a party decides to regulate the price of the domestic supply to consumers of electricity or natural gas, it may do so only to achieve a public policy objective and only by imposing a regulated price that is clearly defined, transparent, non-discriminatory and proportionate. The UK-EU Trade and Cooperation Agreement contains only relatively minimal provisions on oil and gas more broadly. In particular, Article 29 provides procedural requirements on granting authorizations, in particular for hydrocarbons and generation of electricity. And one of the questions we had in from a speaker ahead of today was whether Article 29 is likely to require a step change in how new generation capacity is authorized by Ofgem. And I think the key planks of Article 29 are to require that authorizations for particular electricity generation are based on objective and non-discriminatory criteria, which I think already fairly apply. And the only issue is ensuring that that criteria is published in a particular timeframe in accordance with the general conditions and procedures which are set out in Section 1 of Chapter 5 of Title 2 concerning the regulatory framework of services and investment more broadly. Ofgem is currently consulting on licence modifications to ensure that licences are fit for purpose after the transition period ends, and expects to publish its final modification direction in January 2021. There's also a requirement in Article 29 that each party provides the applicant for authorisation with a right to appeal any decision concerning the authorisation to an authority higher than or independent from the authority that issued the decision, or to request that such a higher or independent authority review that decision. Now, there is an internal review process within Ofgem which wouldn't satisfy that requirement, but I think this requirement is likely to be satisfied at the very least by the safeguard of judicial review. And with that, I now hand over to Stephen to address the enforcement provisions.
Thank you, Gethin. I'm going to be fairly brief on this. There is obviously a lot there. One can do really no more than scratch the surface of it in the time we've got available. And I would reiterate that if you want to understand it, a good place to start is the EU's own website on this. There is an excellent set of materials explaining how these provisions work. So we're first of all going to have to get used to the new institutions which have come into being. First of all, sitting at the top is the Partnership Council. That's co-chaired by a UK minister and a commissioner. It must meet at least yearly, and it is assisted by a number of other bodies. First of all, the Trade Partnership Committee. Secondly, a number of trade partnership subcommittees dealing with, for instance, goods, services, procurement, regulatory cooperation, and level playing field. So level playing field arguments will go to the Trade Partnership Subcommittee in general. There are then also a number of committees which deal with matters that I've listed there. That's not exclusive, but it does include energy, and it does include, for example, air transport and fisheries, all of which may be relevant to environmental matters going forward. Next slide, please. The Partnership Council, sitting at the top, decisions are made by, as the agreement puts it, mutual consent of the co-chairs, the two chairs. So unanimity effectively is required. It can make non-binding recommendations to the parties. Its most important function probably is as a forum to try and resolve disputes at a political level before they get into the cogs and wheels that I'm going to describe in a moment. It also adopts lists of arbitrators who will operate those cogs and wheels to an extent. The Commission represents the EU in the Council, and the Commission, it should be noted, is committed to a high level of transparency and sincere cooperation, both with the public and with the European Parliament. So we can expect these disputes to be played out at quite a public level. That's quite different, isn't it, to many disputes which go on under trade and investment treaty arrangements, where it's all really done behind closed doors. This, I think, is going to be done in the full glare of day, with the public and the European Parliament involved, certainly as far as the EU is concerned. Next slide, please. Dispute resolution, how does this work? So a dispute arises over level playing field matters, for example. There is, first of all, a month of consultation. There is then reference to an arbitration tribunal, the arbitrators, as I've said, being appointed by the Partnership Council. That tribunal will give a ruling. The infringing party must then comply with that ruling within a reasonable period of time. A period of up to 40 days is given for proposals to be made and agreed as to what is reasonable. The complaining party, if that doesn't arrive at a satisfactory position, may request the tribunal, the arbitral tribunal, then to rule on compliance, with a 45-day period allowed for that. These are quite short periods in terms of arbitration, so it's a pretty fast-track procedure. If there is found to be a persisting lack of compliance, then there can either be temporary compensation agreed between the parties, or the offended party, the EU, for instance, against the UK, can unilaterally suspend obligations in any area: trade tariffs, air traffic rights, access to fisheries or water. So it doesn't have to relate to the area of offence. The arsenal of unilateral suspension of its own obligations under the agreement can apply in any area. If there is still a dispute over that suspension, it goes back again to the arbitration tribunal. So it's a fairly hard-edged system, you can see. Next slide, please. Parallel with this, complementary to it, there is also a system for panel of expert determination. That is the dispute settlement mechanism for certain areas. That includes climate neutrality, labour and social standards, and environment and climate. There's a number of differences to the arbitration process. First of all is that built into the panel of experts process is a 90-day consultation with the DAGs, the domestic advisory groups, who are intended to provide a balanced representation of civil society. So this again is not some sort of private, behind closed doors investment treaty arbitration process. It is intended, if you get into the areas of environment, climate, labour and social standards, to be a very open and cooperative process with both sides consulting with their domestic advisory groups. There is then reference to a panel of experts. that panel of experts has 7 months to decide on its recommendations in its report. The panel reports, the respondent party then must inform the DAGs and the other parties of the measures which it's going to take or has taken in response to the panel report. If that is not satisfactory, the complaining party may ask the expert panel then to rule on whether there is a persisting lack of compliance, and the panel has 45 days to make that ruling. If there is a persisting lack of compliance, then we get back to the same suite of possible sanctions as for the arbitration mechanism. And again, if there is a dispute, the expert panel will resolve those disputes. So next slide, please. There is a process of remedial, rebalancing and compensatory measures, which is intended to complement the dispute resolution mechanisms that I've just described. And that is a set of measures which is available to each party. If you want to find them, it's very conveniently set out in the EU's Council signing decision on the EU website at Article 3. But it includes, for example, subsidies, fisheries, rebalancing measures in the areas of environmental and climate protection, which have a material impact on trade or investment between the UK and the EU. The measures which can be taken in response to non-compliance are appropriate measures which are to be restricted in scope and duration to what is strictly necessary in order to remedy the situation. So there is a proportionality principle built in, and priority should be given to those measures which will least disturb the functioning of the trade and cooperation agreement. If there is a dispute over remedial, rebalancing or compensatory measures taken by one party, then that may be referred to the arbitration tribunal, and a 30-day expedited procedure is available. If that procedure is invoked and after 30 days no ruling is given, then the other party may apply their proportionate countermeasures until the delivery of the ruling. So this is really, it's quite a complicated and it's quite a hard-edged set of obligations, this. You can see how this is going to be a potentially very fertile area for public international lawyers in the future as these disputes arise and if they're not resolved politically. So next slide. So I think that basically has covered what I wanted to say on enforcement. It's only giving you at the moment the barest outline, but I think you can see how it's going to work from that. We've used up pretty much, overused up our allocated measure of time for this, but I am going to give an opportunity in a moment for a couple of questions to be followed up with the speakers. But before I do that, I'll say thank you for attending. The slide pack for today is available on our website shortly, so you can obtain hard copies or soft copies of our slides via the website. We have coming up the next webinar on the 15th of March, looking at specific provisions of the TCA. And as I said, we'll invite you, if you wish, to suggest what we might cover in that, and you will find an invite shortly. So next slide. Also, just a reminder, look at our resources online. We have a whole lot of podcasts, webinars, newsletters, including on the Environment Bill, which you can access on our website. And I think the last slide is simply our contact details. So I'm just going to invite Ruth and Gethin to come back online, as it were, and just try and deal with a couple of questions. While they're thinking about it, there was one question which I picked up, which I'll try and deal with very briefly, and that is, well, what about mutual recognition of standards? That's a very big question, of course. There are a whole suite of provisions on technical barriers to trade under Article TBT of the Trade and Cooperation Agreement, which references and incorporates quite a lot of the WTO TBT agreement. So there has to be cooperation and transparency when each side prepares technical standards, which may represent barriers to trade, and a commitment to use relevant international standards, so ISO standards. And there are also important provisions on labelling, how far can products be labelled, and how that labelling is to be carried out. It's going to be interesting how these play out. It may be a good issue to look at in a future webinar, possibly, but you can see a big issue looming here, really, which is not only the product itself, the standards of that product, but how the product was produced. Was it produced in a carbon intensive way? Not just is it carbon intensive when the consumer uses it, but was it produced using carbon intensive techniques? And that could be extremely contentious, I think, if one looks at WTO case law, such as the US and Mexico very long running inconclusive dispute over catching tuna and catching dolphins in the nets. You can see that is a debate that could really run and run. So in answer to the question, there is an awful lot about technical barriers to trade, mutual recognition of standards. In the agreement, you'd need to read it, and you'd need to read the WTO TBT agreement that goes with it. So I'm just going to give, having said that, I'm going to give first Gethin and then Ruth an opportunity, if there's a question they've picked up online that they want to answer online, just to do that. You don't have to, it's just giving you the chance.
Thanks, Stephen. There weren't any specific energy questions, save for one that came in ahead of today, which related to Section 29 of the European Union Future Relationship Act 2020. And what Section 29 does is it provides that existing domestic law having effect for the purposes of implementing in law the Trade and Cooperation Agreement, so far as the agreement is concerned, not otherwise implemented specifically through legislation, must be applied in a modified way so as to give effect to the UK's compliance with the Trade and Cooperation Agreement. And the question was whether or not, which aspects of the energy provisions were most likely to essentially override domestic law by virtue of Section 29 of the European Union Future Relationship Act. And I think that the two key principles that have the most bite are the principles of non-discrimination in respect of the gas and electricity markets and the complementary prohibition of market abuse. Those are the harder edged obligations in the agreement, again, replicating the former remit regulations. And so to the extent that it's likely to create differences in the base level of protection regulation, given that there's already pre-existing commitment to maintaining standards, it's probably likely to be relatively minimal.
Thanks, Gethin. Ruth, did you have anything you wanted to add by way of response to any questions?
Yeah, thanks, Stephen. So there's been an interesting question on the scope of Article 7.1. So you might all remember that slide, which had quite a long list of the things that were included, but I think we have a good question on whether that list is exhaustive. And looking at the wording, there's a little passage buried in the first sentence there where it says that environmental levels of protection mean the levels of protection provided overall in a party's law which have the purpose of protecting the environment. And then we go on to a list of including. So I think there's been a notable omission there, which one of our questioners has noted, but I think there's probably some opportunity to sweep up those omissions by arguing that something comes within a party's law, depending on what we're seeking to argue. So I think that's an interesting question, and again shows the fertile ground here for wondering what is in and out of scope in terms of Title 11.
Okay, thanks very much. Well, we've trespassed on your time. I think we've run over, but I hope you found it useful. We've had a good number of you online, I think over 100. So thank you, well over 100. So thank you very much for joining us. And we hope that you will join us again for the next of these events. If you want to get in touch with any of us with any further questions or comments, then of course you're very welcome to do so. But I think I'll close now and say thank you for attending, and I wish you all the best for the rest of your week. So goodbye from the three of us.